Section 23, Protecting Homeowners, Don't Default. A few days later, Melissa received a phone call from a homeowner named Carlos. His voice sounded exhausted. "I've missed several mortgage payments," he admitted. "The lender keeps sending letters, and now I'm afraid I'm going to lose my house." Melissa listened carefully. "I don't know if there's anything left I can do." Rather than trying to answer every question herself, Melissa scheduled a meeting with Carlos and invited David to join them. As they sat down in the conference room, David began with reassuring words. "Carlos, the most important thing you need to understand is this. Receiving a foreclosure notice does not always mean you've run out of options." Carlos looked relieved. "So there's still time?" "In many situations, yes," David replied. "The earlier homeowners seek help, the more opportunities they usually have." He explained that foreclosure is not simply the loss of a home. It is a financial event that can affect nearly every aspect of a homeowner's future, including credit, borrowing ability, insurance rates, and future housing opportunities. That is why realtors should understand the resources available to homeowners while recognizing when legal and financial professionals need to become involved. Melissa asked, "One of the first questions homeowners usually ask is whether they'll still owe money after foreclosure." David nodded. "That's where Arizona law provides important protections." He explained that one of the greatest financial concerns for homeowners is the possibility of a deficiency judgment. A deficiency occurs when the property sells for less than the amount owed on the loan. Under ARS Section 33-814G, Arizona generally protects borrowers from deficiency judgments following qualifying trustee sales involving certain owner-occupied single-family residences and duplexes. These protections help reduce the financial burden many homeowners fear after foreclosure. However, realtors should never assume every property qualifies and should recommend that homeowners consult qualified legal counsel regarding their individual circumstances. Carlos looked surprised. "So even if the lender doesn't recover everything they're owed, I might not have to repay the difference?" "Possibly," David answered, "but every situation depends on the type of loan, the property, and the applicable law." Melissa added, "So our responsibility is helping homeowners understand that protection may exist, not promising that it always applies." David smiled. "Exactly." He then shifted the conversation to another option homeowners sometimes consider. What if someone simply needs more time? He explained that when foreclosure becomes imminent, some homeowners consult bankruptcy attorneys. Filing bankruptcy may trigger an automatic stay, temporarily stopping foreclosure proceedings and collection efforts while the court reviews the case. Depending on the homeowner's financial situation, bankruptcy may eliminate certain unsecured debts or provide a structured repayment plan that allows borrowers to catch up on delinquent mortgage payments over time. David quickly reminded everyone of an important point. Realtors never advise homeowners whether they should file bankruptcy. That decision belongs to qualified legal counsel. Instead, realtors should recognize when bankruptcy may become part of the conversation and recommend that clients seek legal advice before making such an important financial decision. Carlos nodded. "I didn't realize bankruptcy can temporarily stop the foreclosure." "It may," David replied, "but it's not the right solution for everyone." Melissa then asked another question. "What if the homeowner can still afford the house if the payments were lower?" David explained that lenders frequently consider loan modifications before completing a foreclosure. Depending on the circumstances, the lender may lower the interest rate, extend the repayment period, capitalize missed payments, or restructure the loan to create a more affordable monthly payment. These modifications benefit both the homeowner and the lender by keeping the loan performing while avoiding the expense and uncertainty of foreclosure. Carlos smiled. "So calling the lender early is better than ignoring them." "Absolutely," David replied. "Communication is one of the most valuable tools a homeowner has." He explained that borrowers who remain in contact with their lender and respond promptly to requests for financial documentation often have more opportunities to explore alternatives than borrowers who ignore notices until the foreclosure process is nearly complete. Melissa then shifted the discussion toward the realtor's role. "So where do we provide the greatest value?" David answered without hesitation. "Education." He explained that realtors help homeowners understand available options, encourage early action, coordinate communication with lenders, and recommend qualified legal and tax professionals whenever questions arise outside the scope of a real estate license. While realtors cannot solve every financial problem, they can help homeowners avoid making costly mistakes simply because they lacked accurate information. Carlos thanked both Melissa and David. "I wish I had made this appointment months ago." David smiled. "Many homeowners say that, but the important thing is that you're asking questions now." Before ending the meeting, Melissa brought up another important issue. What about disclosures? If someone is losing their home, do they still have to disclose problems with the property? David became serious. "They absolutely do. He explained that financial hardship does not eliminate a seller's legal obligation to disclose known material facts. Arizona case law has consistently reinforced that disclosure duties remain the same regardless of whether the property is a traditional sale, short sale, or foreclosure-related transaction. David then discussed the Arizona Court of Appeals decision in Hill v. Jones, 1986. In that case, he explained, the seller failed to disclose known termite damage. The court ruled that sellers have a duty to disclose material facts that are not readily observable and that could affect the property's value. Financial hardship does not excuse non-disclosure. Melissa nodded. So even if a homeowner is under tremendous financial stress, they still must disclose known defects. Exactly. David continued by discussing Jennings versus Lee, 1969. That case reminds realtors that our fiduciary duties extend beyond simply marketing property. Brokers must disclose material information affecting the transaction and continue acting in the best interests of their clients throughout the process. He explained that distressed transactions often involve greater pressure, tighter timelines, and more uncertainty, making honest communication and proper disclosure even more important. As Carlos prepared to leave, he looked far more optimistic than when he had first arrived. I thought foreclosure meant I had no choices. Today you learned something different. Foreclosure may create difficult decisions, but understanding your legal protections, communicating early, exploring available options, and working with qualified professionals can dramatically reduce the financial strain. Melissa reflected on the meeting as Carlos left the office. She realized that protecting homeowners isn't simply about helping them sell a property. It's about educating them early, recognizing available legal protections, encouraging professional guidance, and ensuring that every transaction is handled with honesty, transparency, and full disclosure. In the next section, we'll examine additional practical strategies realtors can use to guide homeowners through distressed transactions while maintaining compliance with Arizona law and protecting the public. Online discussion. Discussion question 1. Why is it important for homeowners to seek assistance early in the foreclosure process? Answer. Early action provides more opportunities to explore alternatives, such as loan modifications, repayment plans, bankruptcy consultation, or other loss mitigation options before foreclosure progresses too far. Discussion question 2. Why do disclosure obligations remain the same during a foreclosure or short sale transaction? Answer. Arizona law requires sellers to disclose known material facts regardless of their financial circumstances. Financial hardship does not eliminate a seller's duty to disclose material defects that could affect a buyer's decision. Discussion question 3. How do the cases of Hill v. Jones and Jennings v. Lee help protect consumers during distressed transactions? Answer. Hill v. Jones reinforces the duty to disclose known material defects, while Jennings v. Lee emphasizes a broker's fiduciary duty to disclose material information and protect clients throughout the transaction.